Your Honour, if it pleases the court, my name is Hunt, initials TD, and I am acting on behalf of the applicant, Johnny Wishbone, in this matter. My client faces 106 separate charges of breaking and entering. Your Honour, I submit that the police, in arresting my client, have failed to adequately discharge their obligations under the Police Powers and Responsibilities Act and the supporting Police Powers and Responsibilities Regulation, on the basis that the arresting officers failed to adhere to the obligations required when questioning my client as an Indigenous juvenile, and the form of evidence submitted to the court against my client is therefore inadmissible. Your Honour, I raise the following issues in my submissions. Your Honour, my client was a child as defined under Schedule 4 of the Youth Justices Act for the purpose of the Police Powers and Responsibilities Act, having not obtained the age of 17 at the time of his arrest or at the time of these proceedings. Your Honour, it is also relevant that my client is of Torres Strait Islander descent. The facts I assert were made known to the officers at the time of my client's arrest. Your Honour, I submit that during the arrest and prior to the initial questioning of my client at the scene, the attending officers had failed to caution my client as required under Section 431 of the Police Powers and Responsibilities Act, which stipulates under subsection 1 the police officer must, before questioning a person, caution that person. Your Honour, the police also failed to advise my client of his rights to silence under Section 397 of the Police Powers Responsibilities Act and Regulation 26 as contained in Schedule 9 of the Police Powers and Responsibilities Regulation. Your Honour, the arresting officers subsequently drove my client around the area of his arrest in an unmarked police car, posing questions to my client to the effect of, "Did you break into that house over there? What about that house over there?" To which my client responded, "Yes, I think so. I'm not too sure. I can't remember." I submit that these responses are clear examples of gratuitous concurrence due to my client being intimidated by the officers, which I further submit poses an issue about the voluntariness of his alleged submissions. My client was then taken to a police station far removed from his area of residence and provided with a support person, Your Honour, who told him to just tell the truth and just answer the officer's questions. If I may, Your Honour, I draw your attention to Section 421 of the Police Powers and Responsibilities Act, which states, "The officer must not question the child unless, before questioning commences, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances in which the conversation cannot be overheard and a support person is present whilst the child is being questioned." Your Honour, I submit that at no time, whilst at the scene of the arrest, in the police car, or at the station, my client was afforded his statutory right to silence, or, as a child, given the opportunity to choose his own support person to be present for the duration of questioning as required under the Police Powers Responsibilities Act. Your Honour, I further direct you to find the police officers in breach of Section 418, subsection 1 of the Police Powers and Responsibilities Act, which outlines my client's right to communicate his whereabouts to a relative or friend, or his right to have a relative, friend, or lawyer present during the questioning. I submit that the failure to afford him a support person of his choosing created further instances of gratuitous concurrence during the interview. Your Honour, I also submit, with reference to the rationale of gratuitous concurrence, that my client has answered all questions posed to him in the affirmative due to him being in an intimidating situation without the appropriate support mechanisms. Your Honour, I now address my second issue, that the officers failed to discharge their obligations under Section 436 of the Police Powers Responsibilities Act, which is to electronically record questioning undertaken at the scene of the alleged crime and in the police car. Given the extensive access police officers have to modern technology, I find it very difficult to believe that electronic recording was impracticable or analogous to those examples provided under Section 436, subsection 2 of the Police Powers and Responsibility Act. Finally, Your Honour, I direct you to the decision in Bunning and Cross, and also Section 5, subsection E of the Police Powers and Responsibilities Act, which states, one of the purposes of the Act is to ensure fairness and to protect the rights of persons against whom the police exercise their powers under the Act. Your Honour, I submit that my client was not afforded the right to fair process, and the improperly obtained evidence is highly prejudicial against my client. Therefore, Your Honour, I request that you exercise your discretion pursuant to these decisions in Bunning and Cross and R and Ireland on fairness and public policy grounds, and dismiss the Crown's evidence against my client as inadmissible on the basis that it has been obtained by improper means. Thank you, Your Honour.